May it please the Court? My name is Jason Morgan. I represent Creative Playthings, which is, for practical purposes, the appellant before you. As you know from the papers, this is a certified question that was sent up by Magistrate Judge Collins, so there isn't technically an appellant or an appellee, but through some agreement we decided to go first, for better or for worse. The general principles that are at issue today are basically freedom of contract principles, and they're well established. They've been well established in the Commonwealth. They've been well established throughout the country. And essentially what Mr. Reiser would have the court do is essentially reverse a long-standing, basically universal principle of freedom of contract, which would be to say that the parties are not, in fact, free to contract and to agree upon terms.
Well, let's assume you are correct and the parties do have a certain amount of freedom. I gather those courts which have given the parties that freedom have restrained it and said it must still be reasonable.
I would agree with that, and in following the U.S. Supreme Court's decision in Wolf, there certainly would be that element that would exist, that the parties would be free to contract so long, in this case, if they were to set a limitation on the ability and timing of suit, that it would have to be reasonable, as determined by the court.
This provision has both a limitation period and a repose period. And
correct.
Would a repose period fit within the doctrine of reasonableness if it means that a plaintiff may not be able to file suit upon the moment of discovering the wrong?
Absolutely. I think that if you were to essentially follow Wolf and say that you can apply limitations periods, they could apply to what would otherwise be a statute of limitations, contractual, or a statute of repose, contractual repose.
But we at least have very sharply distinguished between a statute of repose and a statute of limitations. Does the other? I've not had a chance to look at the federal case law. Does the federal case law keep that distinction or even speak of repose?
I have not found the same level, or quite frankly, you know, any of the cases that would interpret a contractual repose period. Certainly, the principle of allowing parties to agree upon a repose period would seem to be consistent with freedom of contract principles and consistent with Wolf.
But this is a certified question. I guess following up on that, the question is posed in terms of statute of limitations. Does that mean we should answer the question about the 18-month repose provision, or is that not before us? That's question number one.
I would suggest that that's not before the court. What is before the court is whether or not a limitations period, a limitations provision in a contract that allows parties to limit the period under which they can file suit against each other is valid. Now, the court might say subject to reasonableness.
If we answer the question, yes, it's consistent with Massachusetts law, when it goes back to the federal court, is then there going to be a trial on whether this limitations period is reasonable or not, and B, what happens to the repose piece of this?
There already has been a trial. It just occurred in January. But the element of reasonableness certainly would be a legal decision that Magistrate Judge Collins would have to make. I think what he has done is essentially said, before I get to that reasonableness question, I want to find out from the Honorable Court whether or not these types of provisions that do limit are in fact valid and enforceable. And then Magistrate Collins can then go and make the decision whether or not on a contractual limitations argument or provision, if 1 year is reasonable, because that's what we have here, or on a contractual repose period, whether 18 months is reasonable, which is what we have here.
But I thought you just answered that it wasn't before us about the 18 months because it was a repose.
I'm sorry, I don't follow the question.
Well, my question was, do we look at both pieces of this, the limitations, what we would call the limitations period, and what we would call the repose period? Are both of them raised by Magistrate Collins' question, or is it just the first?
I guess I would suggest that if we look at the actual question, for that arguably limitations alone was carved out in his question, although I suppose it could be read loosely that the limitations provision that included both the repose and the limitations provision were to be included.
Was that discussed at all before him?
It was not.
It never came up that one was one thing and one was the other?
It was not, Your Honor.
And is this really only within the context of franchise contracts? Because the judge pointed to the Puleo opinion in the appeals court, the footnote, which wasn't, it was a very different context. It had to do with an employment situation. And certainly there's more discussion, it seems to me, in the literature about the viability of those kinds of limitations, shortening provisions in some contexts more than in others. Are we being asked to answer this question sort of as a general matter or just as with respect to franchise contracts?
Magistrate Judge Collins' certified question specifically says a franchise agreement. I would suggest that the principles would apply equally to a franchise agreement as they would to any other commercial contract.
So you're just commercial contracts, though. That's all you're talking about.
Well, I guess, good point. I mean, I would suggest that the freedom of contract principles would apply to any contract, but I don't want to distinguish between when we're talking about an employment situation versus a business-to-business. I was reading into that as a commercial context. I would certainly see there should be no attempt to define as between commercial contracts, but I suppose that the court could make the decision in the context of certain other individual contracts, things that might be governed by ERISA or things like that. They may have some different protections, but
there are a lot of, statutes of limitations are, not only are they important to sort of limit the period, but they're also important to ensure that certain claims can be brought and that certain individuals have protections, particularly in the tort area, medical malpractice. There's a whole range of areas, and so it does make a difference if it's in the commercial contracts. And I see that New England Legal Foundation is really just arguing for a business-to-business freedom of contract, not more extensive. Do you agree that there is a difference?
I would agree. I agree that there could be a difference. I wouldn't suggest that there is a bright line as between all individual type contracts and all commercial contracts, but I would agree, without being able to identify a specific example, that one could come up with an example of a contract that might want to be treated differently for equitable reasons.
Well, could a doctor enter into a contract with a patient that incorporated a one-year statute of repose as to any claims of malpractice?
I would suggest that if the court made the decision on that, if it was deemed to be, if there was a general freedom of contract understanding, the court would have to determine whether that was reasonable. And I would suggest in that particular context, my guess is that the court would say it's not reasonable. So to be consistent with Wolf, the general principle would be that it is valid to limit, and so long as it is reasonable, and if the court determined that 1 year was unreasonable, then that particular provision would not be valid.
And does your view of reasonableness apply only to the amount of time, or can it also apply to the adhesive nature of the agreement? Would you apply this to contracts of adhesion?
Well, I guess we open up a whole other can of worms with contracts of adhesion. Some are deemed valid in certain circumstances, and sometimes they're not. And I would suggest the general principle, which I think is what at issue, is that, yes, they are valid subject to a host of other things. You have a variety of things that the courts look at. Is a contract clear and unambiguous? The court has already found, Judge Collins, that it is. Is it viewed as a whole? Do you read it as a whole? Is it negotiated at arm's length? There's a whole host of different elements that are sort of general contract principles that will always apply. We're not suggesting that those should be disregarded.
But the very nature of an adhesion contract is that it's not negotiated.
True. And in this case, it's not before the court, but the facts are, to the extent that Your Honor cares, it is a negotiated contract. It was actually negotiated by Mr. Reiser's lawyer and my client, Creative Playthings. So to the extent that that is an important element, it actually would weigh in favor of the enforceability of the provision in this case.
To what extent does the legislative judgment about what a period of time should be incorporate itself a principle of reasonableness to which the courts should defer?
There's two parts to that, actually, I think, and it's a good question because part of what the legislatures have done in Massachusetts is they've said we're going to set a 6-year statute of limitations for contracts and 3 years for torts and 4 years for 93A. What the legislature has done is it has made that determination that that is the maximum. So that is the end cap.
Except for the discovery rule.
except for the discovery rule. And in this case, in the case law that would interpret this would say the discovery rule, a statutory discovery rule, does not apply to a contractual limitations provision. And in particular, this contractual limitations provision has its own discovery rule. It is basically 1 year within discovery, you must bring the suit. But the second part of that question is actually a good one that is raised by the U.S. Supreme Court in Wolf, is that absent a statutory provision in that state that would not allow a party to limit, the parties are free to contract and can limit so long as the limitation is reasonable. And if you look through, and we've scoured the country, and there are a handful of states that actually have statutes, specific statutes, that say parties cannot change the statutory limitations. Statute of limitations.
But in Massachusetts, does that arise by implication? Because under the Uniform Commercial Code, there is specific language that authorizes the parties to change the period of limitations. In other statutes, it's missing, it's absent. So by implication, where the statute does not allow for the alteration of a limitations period, should we imply a legislative intent that it not be modified?
I would suggest it's just the opposite, Your Honor. I would suggest that where there is a general rule laid out by the U.S. Supreme Court that says unless there's a statute to the contrary, parties can agree to limit the time period. Where there is nothing in a particular area, so here the UCC, the Massachusetts legislature, has said the parties are allowed to agree, but they can't go less than a year. They also have done that in other contexts, in other areas, where they've said in this particular area, defined as whatever it might be, an auto dealership, you can't go below 2 years. So in particular areas, the Massachusetts legislature is aware that, I mean, generally the Massachusetts legislature is aware that parties are doing this, and in particular areas where they think it's important, they're actually saying, okay, you can do this, but don't go below this threshold. And so as applies to this contract that's at issue, there is no particular industry or area that has said, you know, in this particular franchise context, you cannot go below a certain point. So I would suggest it's just the opposite, that unless there's something that speaks directly to our relationship, our industry, whatever it is, that the parties would be free to contract and could, in fact, agree to limit the period.
So the U.S. Supreme Court has spoken in a way about this, but you would agree with me there are no federal issues here, there are no constitutional issues here. This is strictly state law, common law, statutory law.
As to the claims that Mr. Reiser has brought against Creative Playthings franchising, I would agree that they are state-specific.
Well, this question about whether the parties can contract for a shorter limitations period, you would agree that that really is a state law question, thoroughly.
I would agree that there is a question. Again, this wouldn't be a factual question for the court to determine, but arguably, Justice Spina raised a question about the UCC. Arguably, this is a franchise that exists for the purposes of a sale of goods, the sale of swing sets. And to the extent that Judge Collins made the determination that in fact the UCC would apply to this, then we really don't even have a question. Now, he hasn't gone that far, and it hasn't really been something that's been before him as an issue. But arguably, it could be argued this is a moot point in the sense that the UCC that allows for a one-year limitations provision for the sale of goods.
Doesn't allow for an 18-month statute of repose, though, does it?
The statute of repose would be a different issue. I agree. In this case, we have, I guess, argued both to Judge Collins, again, depending on how Your Honors reads the issue that was presented as to whether or not you would address the statute of repose or limit it to the contractual limitations provision. I would suggest that, generally speaking, it's a question of validity of the parties to freely contract within the bounds of reasonableness and allow the trial judge to make the decision on whether or not a particular provision is reasonable, and that would be consistent with everything.
Is there anything about franchises that makes them particularly amenable to this concept, to the, and in particular, the kind of standardization of business practices across the country, the uniformity of business practice?
There is, actually, and part of what that is that you have very defined federal regulations that are invoked with a uniform franchise offering circular, the information that's presented to a franchise, and specifically with those things come a whole host of different things, sometimes state-specific, but there is a general, I see my time is run, can I finish the question? So I would suggest, to the extent that there is a bend with that, it actually would weigh in favor of allowing the enforceability of a provision like this within the context of a franchise agreement, because much like the UCC, you're talking about in large respects, uniform contract provisions. And if you look at the federal case law, and if Judge Collins had simply relied upon the First Circuit precedent, we wouldn't be here, because the First Circuit has already found that these are reasonable, these are valid and enforceable, if reasonable, and including a one-year contractual limitations provision while not addressing the contractual repose period. So what they have done, what the federal court has done in this district, has said in these contexts, even in franchise agreements, sometimes even in cases where it's, you know, massive company, Mobil Oil, and a small gasoline operator franchise agreement, that these are the kinds of situations where these things are amenable to freedom of contract principles, that the parties who are intimately involved in the relationship can agree, and they are bound by what they agree to.
Thank you.
Thank you.
Chief Justice, Your Honors, may it please the Court, my name is Judith Lane. It is my privilege to represent Mr. James Reiser here before you today. In addressing a couple of the issues that the Court brought forward, I think it's important to note that there are some loose language in the cases when we refer to limitations period. And what we're really talking about are three different types of limitations. You have limitations based upon statute of limitations, you have limitations by virtue of statute of repose, and then you have limitations in the form of condition precedents that we find in contracts for purposes of notice. And some of these cases confuse the issue very clearly when they talk about the fact that the parties have contracted to limit the time between them.
What do you think we should be answering in this case?
It's a good question, Your Honor. I agree with my brother, Mr. Morgan, that we did not address the statute of repose issue with Judge Collins. In fact, it didn't even occur to me until I saw the Amica brief and started looking at this issue. I recognize that this case decided by Creative Playthings were clearly notice issues, and somehow they didn't seem to fit. They were conditions precedent. But I think Judge Collins would want an answer as to all of it, because we are dealing with a very specific contract that he wants to interpret and get right, and he's waiting for Massachusetts to tell him what the law is. And I will say that I can find no case in any state, in any jurisdiction, or in any federal court that permits the parties to contract away a statute of repose. And the reason for that, I believe, is because a statute of repose...
It's not contracting away, it's contracting one. I mean...
Exactly right. And by virtue of that, it's contracting out of a statute of repose or shortening a statute of repose. And I think the reason for that is because statutes of repose do not include any ability for the discovery rule to apply. It sets an absolute maximum. Usually in some cases for fraud it's 12 years, or for products liabilities it's 15 years, and it's designed to get to an end whether you know about it or not.
Is that an important feature here?
I think it is.
Is there a statute of repose that exists that applies here, apart from the contract?
No, Your Honor, there's not. And in this particular case, there's now an 18-month statute of repose.
No, I understand that, but I mean, you said it's contracting out of one. Is there one that would apply otherwise?
No, Your Honor, not at all in this particular situation. What I was referring to, and excuse me, was just the fact that when they do exist, I can't find any statute or any case anywhere that would allow you to even shorten that. So in this case, there would be none at all, and we're trying to make it 18 months.
But is there case law that supports a restriction on the discovery rule by contract?
I'm not sure I understand your question.
Can you agree that there is case law that will shorten a statute of limitations?
Yes, Judge.
Is there case law and there's case law that prevents the shortening of a statute of limitations? Is there case law that supports the elimination of a discovery rule as it applies to a statute of limitations? In other words, you have 3 years, essentially creating a statute of repose by eliminating a discovery rule.
I believe in Massachusetts there's a tolling provision with respect to the discovery period as well that actually says a discovery period can be a shortened period of time where it can be a statute, where it becomes a statute of repose. But they're much longer. I mean, they become a much longer and a larger burden. But it's a tolling period that exists. If I understand your question correctly, and I'm not sure that I do, but ultimately there's a period of time. I'm not aware in the context of a statute of limitations issue where they ever say that you only have 3 years to discover something before the cause of action begins to accrue.
Well, could a hospital enter into an agreement with a patient to the effect that you can only bring an action against us for malpractice for 3 years from the date of the event?
I don't believe in Massachusetts they could, Justice, and here's why. That's the other issue that I think is important in this particular case. It appears to me that cases, or the states deal with the shortening of statute of limitations by way of contract in 3 ways. One, they either specifically prohibit it. There's a number of cases we have that prohibit anybody from contracting out: South Dakota, Washington, Indiana. There's a number of cases like Utah who probably would not permit that because they draw a distinction. They'll allow certain...
I'm sorry, and do it because the courts say so or because the legislature says so?
In the context of South Dakota, Washington, and Indiana, it's because the legislature says so. In the context of Utah, it's because the court says so. And what the court said in a Crosstown versus First Insurance is that they were going to split it out. It was a statute or a contract that limited a statute of limitations. And I apologize, but I don't remember the exact facts of the case, but they said what could arise would be cases in contract and cases in tort. We will allow you to shorten the limitations period under the contract, but not allow you to do it under the tort, because it was by its nature a contractual provision. Then there's this third type of cases, and I think this is where Massachusetts applies, where it only allows the limiting of a statute of limitations by way of exception, not by way of general rule. In what we know from looking at all of the Massachusetts statutes is that the general Massachusetts statute of limitations are contained in Chapter 260. In Chapter 260, we have 20 years, 6 years, 3 years, various statute of limitations. And then at Section 19 of Chapter 260, it states if a special provision is otherwise made relative to the limitations in any action, any provision of this chapter here inconsistent herewith shall not apply. Based upon that, we now have a myriad of other statutes that have in fact gone out of their way to specifically change statute of limitations in varying contexts. Chapter 249, it deals with certiorari, it's 2 years. Chapter 153 does workers' compensation for 2 years. Chapter 84 does defects in public works for 3 years. 151 is minimum wage. 159 is common carriers. We have 25 or 30 different statutes outside of the context of Chapter 260 that provide for a different statute of limitations, even though they involve contracts, even though they involve torts, even though they may involve consumer rights issues that are also generally encompassed under Chapter 260. Only 2 of the specific statute of limitation chapters that are outside of Chapter 260 permit the parties to change the terms of the statute of limitations. Those 2 are very important because those are the ones that are the only ones that Massachusetts courts have recognized as permitting parties to change a statute of limitations and make it shorter than what the special statute of limitations is under the Act.
Wouldn't you expect, if there's going to be a limitation imposed on what would seem otherwise a contractual right between, in this case, 2 business parties, wouldn't you expect that there would be, as in South Dakota and Washington, whatever, a specific statutory provision barring that right of contract?
Not necessarily. I think the legislature can handle it in 2 ways. One, they could have an absolute prohibition, which is absolutely permissible. I think the other way they can choose to do it is say, as...
By implication?
Not by implication. In fact, it's the opposite of implication. The courts, or the legislature in Massachusetts is very clear when they are willing to permit parties to contract a different statute of limitations. One is under sale of goods, under Chapter 106, 2-725. It says, in that case, a sale of goods statute of limitations is 4 years, but by agreement, the parties can modify it. Therefore, the legislature of this state knows how to tell people that if they're...
Was that part of what was written by the by the commissioners of the uniform law? I mean, was that part of the UCC to begin with?
It was, and it was adopted, and that provision was adopted by the Massachusetts legislature. But importantly, and Amicus makes a statement that I don't quite understand, the comment in 1957 to that agreement that says that the change was made says they can find no comparable statute anywhere suggesting that you can contract out of that statute of limitations. It was a first, and it drew attention to that. So that's the first time, and the notes note that this is the first time.
But the amicus also cites a case, Amesbury versus Bowditch Mutual, in the 1850s, where this was specifically approved. The court specifically said that you could reduce the 6-year statute of limitations to a period of, I think it was 1 year, and they saw no reason why you couldn't do it in the contract context.
Yeah, I disagree with some of the cases cited by Amicus for a couple of reasons.
Well, what about that case? That case says that you can do it.
I recognize that it says that you can do it, but even where there is common law in point, that doesn't mean that a statute can't come along after the fact. These statutes have all been amended since, and the statute can supplant the common law. It can be in opposition to it. This is not a case of statutory construction where you need to look at whether or not this is a giant derivation from the common law. This is a case where you need to decide whether there is a general public policy statement under the statutes of limitation stepping away from what has been known to be the common law in the state of Florida, because there's no ambiguity in the statute, because it's not unclear whether or not one may or may not amend. We know when they can amend. This is not a case where you have to say that this is a statute that is supplanting common law. I think that case is a bit of an aberration, just like I think the Wolf Court is. When you take a look at the Wolf Court decision, the Wolf Court makes a broad statement that it seems to be the law of the land that parties to a contract can determine when they want the statute of limitations to be modified. Well, that speaks to the entire country. It was published about 1 year after Erie Railroad said there is no common law at the federal level for the states. We know that the state of Massachusetts hasn't made that decision, and we know that only 2 very recent decisions have ever allowed for the exception to the statute of limitations to be amended by virtue of contract. And so I think for that reason, you don't apply. One of the most recent cases out of this court, which is GE versus Department of Environmental Protection, 429 Massachusetts, says exceptions to a statute are not to be implied. And that's where I think it's different from Amesbury, where there's an express exception, where there's it expresses a limitation on the operation of the statute. No other exceptions shall be applied.
But the GE case was not a contract case.
It was not. It was actually a public records law. But what it permitted was the abrogation of the work product privilege, which is in some ways as significant a public policy concern as is a statute of limitation.
There have been later cases, but we won't go there now.
Very
But
good.
in any event, my point is more to the fact that it wasn't
absolutely was a
dealing
difference,
with whether parties could contract.
But in terms of interpretation and statutory interpretation, it said you don't look at a contract to imply an exception. And that's why I would say in this case, Your Honors, we know that there's only 2 places where the legislature has deemed it appropriate to not only change the term of a general statute of limitation, but in doing so, they also went that further step and said the parties as well may contract differently.
And those 2, you said one was sale of goods.
Yes, Judge.
What was the other?
The other one is Chapter 149, Section 29 in bonds. Public bonds have a statute of limitation for enforcement for 1 year. 29A are private bonds, and that statute says that a party may bring a cause of action against a private bond consistent with and as enforceable in the contract. And so it seems to imply that by virtue of the contract, the terms can be changed. It's not at all as clear as Section 106, but it is the only other case that anybody can cite out of Massachusetts that says that a statute of limitations can be modified by way of contract. And in that particular case, that is what happened. If I can point to all of the other cases cited by appellant's counsel, whether it's the Grassy design decision, Albrecht, or La Pueblo, which is the one that Judge Collins had concern with, those are all pre-suit notice provisions. To me...
But, well, if we don't agree with you, what are the circumstances in this case that would compel us to say that it's unreasonable in this case?
Yes, Judge. I think that's another important point, and not all franchisees are the same. One of the issues in this particular case is the relative disparity between the bargaining position of the parties. I know these facts are not before you, but in this particular case, Mr. Reiser had never been in business before on his own. He is an engineer by training. He wanted to buy a franchise that was a turnkey operation, and he went to somebody who had 25 or 30 years in the swing set business and was told, and we allege obviously fraudulently so, that he would be getting a turnkey operation and that he would get his products for a certain price, which proved to be untrue. There are different franchises. For example, some of the cases we looked at in front of Judge Collins talked about franchisor or franchisees who own 6, 8, 10 restaurants. They're not new to the business. They know how the financing scheme is played. They're not a novice, and they're not looking to the franchisor. And again, one of the comparisons we can make is the legislature of Massachusetts carved out a specific exception that I can find for essentially two types, but one type of franchisee that's important, and that's the dealerships, the car dealerships. That's under 93B. They gave the car dealership claims a different statute of limitations, but unlike the Sale of Goods Act, they did not say the parties can contract to modify the terms of that statute of limitations. They could have done so. They elected not to do so. And I would argue under 93B it cannot be contracted away. Car dealers in general are in a much different bargaining position than is the sole franchisee that we have in this case. And so I think in this case it's particularly unreasonable. The other reason it's unreasonable is it took, in this particular case, Mr. Reiser, probably 18 months to build up his sales in a very new area to find out whether or not he could even have sales, to determine whether they met the pro forma that was established by the franchise program that was offered. If it takes you at least 18 months or 24 months to figure out whether the pro forma you've been sold is going to work, but you've already been barred by your statute of limitations and a statute of repose, that to me seems to be inherently unreasonable and unfair.
Thank you, Counsel.
Thank you.